Okay, so welcome back to our channel Independent Training. Today's discussion will be good corporate governance implementations, but in China context. Before we are going to start, don't forget to subscribe, like, and comment to our channel. So today we'll be taking part this presentation from Group 6. We are still in collaboration with University of Mindanao. Want to know more regarding the presentation? So here we go. Okay, thank you for Group 6, isn't it, being here to present. We are still in series Good Corporate Governance Implementations. The first reporter will be Miss Jane.
Yes, sir.
Okay, Miss Jane.
Good afternoon, everyone. I am Shaira Jane Wheeler, taking a Bachelor of Science in Accountancy from the University of Mindanao. And I will be introducing the corporate governance in China as well as the issues that it was able to address.
Okay, thank you, Miss Jane. And then the next reporter, the second.
Good afternoon, sir. Good afternoon, everyone. I'm L.R. Chilean from the University of Mindanao, Davao City, taking up Bachelor of Science in Accountancy. And I will be discussing about the government and legislation in China, wherein it mainly revolves on what system China does follow and what are those authorities that issue rules, regulations, decrees, and instruments.
Okay, thank you, Miss Yala. The third reporter?
So, good afternoon, sir. Good afternoon, everyone. My name is Johanna May Sardido. I am also a student from University of Mindanao, Philippines. And I will be discussing the corporate entities in China, of which I will specifically tackle the foreign investment enterprises, state-owned enterprises, and privately owned enterprises in China.
Okay, thank you, Miss Johanna. Then the next reporter.
So, good afternoon, sir. Good afternoon, everyone.
Hello, Miss Marie.
I am Maria Cataliedo, a student from University of Mindanao. And I will be discussing about the independent director, the Code of Governance for listed companies in China, provided that the China Securities Regulatory Commission issued, wherein the listed companies should introduce independent directors to the board.
Okay, so this is the importance of independent director. And then the last one, Miss Angel, I guess.
So, good day, sir. Good day, everyone. I am Angel Ann Fatima B. Alvarado, a Bachelor of Science in Accountancy student from the University of Mindanao.
Okay.
So, I will be discussing about the committees in the corporate governance of China. So, we all know that committees is a group of people who assist the board upon fulfilling the corporate governance responsibilities and operations. So, most of the companies in China have made a substantial improvements in the establishment of their board committees. So that would be all, sir.
Okay. Thank you, Miss Angel. So thank you once again for being part of this presentation. Now you can start the presentations.
Good morning, good afternoon, and good evening, everyone. We are the Group 6, and for today's topic, we will continue the discussion of corporate governance in international and global context. But this time, our area of focus is China. So, before we formally begin the discussion, allow me to introduce you first the specific topics that we'll be dealing today. So, what do we have here? So first, we will be talking or discussing the corporate governance in China, followed by government and legislation in China. Next to it is corporate entities in China, then independent directors, and lastly, committees. So, without further ado, let's start the discussion.
Good day, I am Shaira Jane Wheeler from the University of Mindanao, and I'm taking up Bachelor of Science in Accountancy. I am from Group 6, and this time I will be presenting to you the corporate governance in China. Corporate law and corporate governance in China have been influenced by a variety of factors, and these are just some. The first is the traditional dominance of the state-owned sector and the continuing ideological commitment by the policymakers to the socialist market economy. Next is the decision by the government to attract foreign capital by encouraging the establishment of foreign invested companies in China and subsequently to encourage the development of a corporatized private sector in order to develop the Chinese economy, and the use of the stock markets in China and overseas. And next is the decision to capitalize upon and expand first state-owned and then private Chinese companies. Chinese decision makers have adopted selected concepts and ideas from a wide range of legal systems in attempting to construct a corporate and securitized legal system that will be appropriate and effective in China. Corporate governance is of concern to Chinese companies of all kinds, whether it be state-owned or foreign invested in private domestically owned corporations. It became an issue of concern for foreign and domestic investors because of the government-backed efforts by state-owned enterprises from the early 1990s to raise money first on Chinese and then on international markets from foreign and domestic investors while maintaining control over the listed vehicle. There are major problems that the Chinese corporate governance addresses. First is the issue of the controlling shareholder and its activities in diverting assets and business advantages from its listed subsidiary. Next is the concern with providing adequate protection for investors in other listed companies and in the fast-growing private sector in China. And then lastly is the interest to the wholly state-owned sector, wherein the Chinese government has stated its commitment to the principle of corporate social responsibility and better standards of enterprise internal controls for state-owned enterprises. But the good news is that despite all of these issues, there is a variegated system of controls and controllers that's been developed in China to deal with these different types of entities and issues. Although the principles of corporate governance imposed on listed companies have attracted much of the scholarly attention devoted to corporate governance in China and are obviously important indicators of how Chinese regulators approach the various issues, it is important not to overlook other Chinese companies and corporate entities, the regulation of which is also clearly causing concerns for investors, other stakeholders, and regulators. That would be the end of my presentation, and I'm leaving you with a quote from the famous and successful investor and philanthropist himself, Mr. Jack Ma. He said that if you want to win in the 21st century, you have to empower others, making sure other people are better than you, then you will be successful. That will be all. Thank you.
So, hello everyone. I am L.R. Gachilian, a fourth-year accountancy student of the University of Mindanao, and I am a member of Group 6. So, government systems, legislations, and regulatory frameworks vary from country to country, and today I will be tackling about the government and legislation of China. This is only a short discussion which will only revolve on how China recognized corporate governance and who are those in authority to issue laws. So let me share my screen to you. Government and legislation of China. So the first question is, what system does China follows? China does not follow federal system. This means that even provincial, municipal, and other lower level governments have the power to issue rules and decrees. But it is important to note that this implementation of legislation is only applicable to its local matters only. So why only those local matters? Because the central government has maintained the strict control over companies and securities law. And one example of this is when Shenzhen and Shanghai had introduced an experimental corporate law regarding their budding stock markets in early 1990s. But there's a but. Okay, these rules were replaced in entirety by the company law and national law regime. So with this scenario or with this circumstance, we could synthesize that the national government or the central government is more in control of the regulatory issues of China. So, what party do we call those who govern the political area of the Chinese community? So we call it Communist Party, or also known as the Chinese Communist Party or CPC. Communist Party plays a leadership role in China, but it is not given a formal legislative role. It is the founding and sole governing political party of the People's Republic of China. After discussing CPC or the Chinese Communist Party, let's talk about who's the main responsible of making law. So, if the Philippines has Congress as the highest lawmaking body, China has National People's Congress or NPC as the premier lawmaking authority. When the body is not in session, it has its standing committee, which is also able to make law, or they are allowed to create or generate laws, the standing committee. So, the Constitution of China had explicitly expressed that the right to legislate or to implement laws for important issues such as criminal law, deprivation of a citizen's right to liberty, civil institutions, and fundamental economic systems such as taxation, trade, and finance lie solely on NPC or the National People's Congress or to its standing committee. It is important to note and to know or to remember that company laws, securities laws, securities investment fund laws, and criminal law should be passed to NPC. Also, the State Council, next one is the State Council is considered as the highest level of executive authority in China. So what is its function? What is State Council? Who is the State Council? State Council is the body which regulates or which issue detailed implementing regulations that explain or clarify areas or matters that need further elaboration or explanation. Those regulations that are in need to be explained. So State Council is responsible for that. And to proceed, we all know that there are a lot of authorities that work together in solving problems through provision of solutions. Now, what authorities are in control of other regulatory matters? So, the following slides will only be an enumeration of varied ministries, administrations, and other bodies under the State Council that issue rules, decrees, and other instruments that have legislative effect. So, let's start with the State Administration for Industry and Commerce, or the SAIC. This is the company registration body, meaning this body is responsible for registration and incorporation of business entities. SAIC has also rules that affect corporate issues on governance. Second is State-Owned Assets Supervision and Administration Commission of the State Council, or this is also known as the SASAC. So, SASAC is responsible authority for centrally administered state-owned enterprises. So they have regulatory, legislative, supervisory role with those enterprises. So SASAC's party committee performs the responsibilities mandated by the Central Committee of the Chinese Communist Party. If China has the body to govern or that regulates its state-owned enterprises, another body governs foreign-owned enterprises or entities, and we call it Ministry of Commerce. So Ministry of Commerce is also responsible for internal and external trade. So the fourth one is the China Securities Regulatory Commission, or also known as the CSRC. CSRC is a primary regulator of listed companies. They are prolific issuers of rules and documents in the securities area. So the following in bullet forms are the concerns or endeavors made in the corporate governance area by the CSRC. So first is the issuance of Code of Corporate Governance for listed companies in China, which was done in 2001. This was followed by the guidelines on introducing the independent director system in listed companies. So, like in Philippines, we all know that independence is important. Independence is important when it comes to directorship, most specifically those in top of the management, which should observe rationality, objectivity, and skepticism in order to have an unprejudiced undertaking of business venture. So, also in 2007, notice on matters concerning carrying out a special campaign to strengthen corporate governance in listed companies was issued. And lastly, in 2008, basic internal control norms for enterprises followed the notice on matters. As a summary, CSRC had issued numerous regulations which are vital to corporate governance that pursue the rights of shareholders of public companies and the requirement of disclosure of essential information. So, another authority in China is the China Insurance Regulatory Commission. So we can get it already from the body, which is this body is primarily responsible for insurance companies. So next is the China Banking Regulatory Commission, which is responsible for regulating banks and financial institutions. So the CIRC, or the China Insurance Regulatory Commission, and the China Banking Regulatory Commission have overlapping responsibilities with CSRC. Why? On what extent? So this is when insurance and financial companies are listed on whether engaged in securities transactions. So when these insurance companies and banking or financial institutions engage themselves with security transactions, then they will have an overlapping responsibility with the CSRC, or the China Securities Regulatory Commission. Next is when we talk about giving opinions, interpretations, and regulations applicable to particular laws, or even handling particular matter, the Supreme People's Court and the Supreme People's Procuratorate is responsible for that area. For instance, the restriction of the ability of the shareholders to bring actions in securities cases is an important notion to prevent slow growth of shareholder litigation. Yes. So we're done with the authorities responsible in issuing decrees and rules, and that ends my report. Thank you for listening, and keep safe, everyone.
Greetings everyone, my name is Johanna May Sardido, a student from University of Mindanao, Philippines, under the program of Bachelor of Science in Internal Auditing. So, I will now continue the discussion and I will be discussing the corporate entities in China. There are three main categories of companies and corporate entities in China. We have state-owned enterprises, foreign investment enterprises, and privately owned enterprises. So let's discuss it one by one and understand the differences between the three. Until the introduction of foreign investment enterprises in 1979, the Chinese economy was dominated by state-owned enterprises which were administered as part of the government rather than as autonomous corporate entities under the control of various branches of the government. So meaning to say, state-owned enterprises, or sometimes referred to as government-owned enterprises, is a type of corporate entity where the government or the state has significant control. Take note, significant control through full, majority, or significant minority ownership in the business. So, it is important to take note that state-owned enterprises is an entity formed by the government for the purpose of engaging in commercial activities. The government usually takes either full or partial ownership of any state-owned enterprises which are typically approved to engage in specific activities. State-owned enterprises here represent the government in commercial endeavors and also sell physical resources to trading entities and corporations. So meaning to say, state-owned enterprises is a type of corporate entity that is created by the government in order to partake in commercial activities on the government's behalf. It can either wholly or partially owned by a government and is typically earmarked to participate in specific commercial activities. So the dominance of state-owned enterprises in the Chinese economy was not accompanied by equivalent level of efficiency or productivity. As such, throughout the 1980s and 1990s, the government made a concerted effort to reform state-owned enterprises through a variety of means, including reorganization, mergers and acquisitions, and privatization and mergers. On that note, a significant step toward formalization of the structure of state-owned enterprises was the promulgation of the 1988 Law on Industrial Enterprises owned by the whole people. So this law vested substantial authority in the factory director, which is appointed by the relevant level of government or is elected by the workers. So in this law, the factory director acted out as the enterprise chief executive officer or the CEO, which is assisted by a management committee composed of employee representatives or leading persons responsible for various aspects of the enterprise. Furthermore, the factory director here served as the enterprise legal representative and assumed the overall responsibility for the enterprise's operations. Additionally, in this law, a board of director or shareholder structure is not required. Moreover, in relation to the enterprise, Article 56 of the 1988 Law on Industrial Enterprises owned by the whole people states that the relevant departments of the government shall, in conformity with the objective, provide services to the enterprises and exercise administration and supervision over the enterprises in line with the respective functions and in accordance with the provisions of the laws and regulations. So meaning to say, the role of the relevant local government here was to formulate policies, coordinate relationships with other enterprises, provide information, safeguard state assets, and improve public facilities. So, the 1988 Law on Industrial Enterprises owned by the whole people was succeeded by a policy requiring the corporatization of the state-owned enterprises. However, despite the birth of the policy, there are still several different kinds of state-owned enterprises in existence, of which varies depending on the history of the entity. In fact, in the examination conducted by the SASAC, it was found out that many of the state-owned enterprises or state-owned corporations have not been converted into corporations under company law and do not have structure including board of directors
and supervisors as required by company law. On the other hand, the fundamental principles governing the management and governance of state-owned enterprises are reflected in the recently enacted Enterprise State Asset Law, which states that the relevant entity of the state should act as the investor of the state-owned enterprises in conformity with the separation of government from enterprises, the separation of public administrative functions from those of state-owned asset investors, and respecting the lawful and independent operation of enterprises. Furthermore, it also requires state-owned enterprises to accept social responsibilities and establish corporate governance systems. Although the number of state-owned enterprises in China has been reduced since 1979 by a concerted policy of privatizations or planned bankruptcies and consolidations, the state-owned sector continues to be strong. On the other hand, let us discuss another main category of corporate entities in China, which is the foreign investment enterprises. So a foreign investment enterprises is a business form which allows an enterprise to invest financially in a business or project in a foreign jurisdiction. It means to say, in relation to our discussion, that these are the enterprises registered and established in China wholly or partly invested by foreign investors, including foreign natural persons, corporations, and other organizations. So modern corporate law in China can be said to date from 1979, with the promulgation of the Chinese Foreign Equity Joint Venture Law. This was followed in 1986 by the Wholly Foreign-Owned Enterprise Law and subsequently by the Cooperative Joint Venture Law. So these three laws, along with their implementing regulations, notices, decrees, and other subsidiary legislation, they continue to define the structure of foreign investment enterprises, which are generally organized as Chinese legal persons with limited liability that issues registered capital rather than shares. However, it was not until the promulgation of the General Principles of Civil Law in 1986 that there was a serious attempt to provide a definition for the concept of legal personality. So moving on, the company law is applied to foreign investment enterprises in a limited fashion. After the promulgation of the amendments to the company law in 2005, the SAIC, or the State Administration for Industry and Commerce, who is responsible for company registration in China, has made a concerted effort to align foreign investment enterprises with wholly Chinese-owned businesses and to apply the corporate structure rules, such as the requirement for the supervisory board and the likes. So this sets out and it is set out in the company law to foreign investment enterprises. So the foreign investment laws and regulation sets out only basic rules relating to corporate management structures, but do not contain detailed provisions relating to corporate governance. As such, the investors may, however, impose corporate governance standards through their constituent documents or internal policies and codes of conduct. So in China, foreign investment enterprises can take in various forms, including wholly owned foreign enterprises, foreign invested companies limited by shares, equity joint ventures, and cooperative joint ventures. So on that note, the structure of joint venture companies in particular does not fit neatly into the management structure contemplated by the company law, since joint ventures are not required to have a meetings of shareholders. Instead, directors are appointed by the parties and may be removed only by the party that is appointed by them. So an advantage of joint venture structure is that the joint venture contract sets out in considerable detail what the relationship is between the investors and how it should operate. At that, the minority party in a joint venture therefore has considerable scope when it negotiates the joint venture contract to incorporate the protection it considers necessary and acceptable. Continuing the key takeaways, in the present time, China recently updated its Foreign Investment Enterprises Law, creating the new FIE or the new Foreign Investment Law, opening up new industries to foreign companies, further protecting foreign interests and making it easier to operate companies in China. Furthermore, China also details how foreign investors can invest in Chinese securities under their qualified institutional investor programs. And now to the last category of corporate entities in China. So the privately owned yeah, privately owned entities are privately owned companies. So privately owned companies are those that does not have structure through which it raises capital or its shares are being held and traded without using an exchange. So normally privately owned enterprises includes family owned businesses, sole proprietorships, and the vast majority of small and medium sized companies. So before ending the discussion, let's take a peek first on company law since this law partakes especially on corporate entities in China. So companies set up under the company law may be privately owned, partly privately owned, or wholly state owned. So these companies may be limited liability companies or companies listed on a Chinese stock exchange or outside China. So the company law was followed by the securities law in 1988, of which both were significantly amended in 2005 in order to provide additional protection and a higher degree of protection to shareholders, particularly minority shareholders. So, in addition, a substantial number of regulations, notices, decrees, and codes of conduct have also been issued largely by the State Council and the CSRC in order to improve the systems and the standards of corporate governance in Chinese companies. So, the company law here provides for a three-tier structure of management. It consists of shareholders meeting, board of directors, and a supervisory board. So the roles and functions of these different levels of management are prescribed in some details in the company law itself. Each company must have articles of association, and some leeways is provided in the company law for the shareholders to modify the relationship between them through the mediums of the articles. So that's it. I hope you learned something about my discussion. Thank you, everyone.
Maria Chai Cataliado, and I'm from Group 6. So the Code of Governance for Listed Companies in China, issued by the China Securities Regulatory Commission, or CSRC, in 2001, provided that the listed companies should introduce independent directors to the board. This was followed by the guidelines for introducing the independent director system in listed companies later that year, which required that by 2003, at least one-third of the directors on the board of a listed company should be independent. So, more than half of the membership of remuneration, audit, and nomination and other committees should also be independent if the listed company has such committees. So, under the guidelines, an independent director must have substantial professional work experience. So, of course, the director must be knowledgeable and have enough work experience, and also must not be related to officers of the company or its subsidiaries, shareholders holding 1% or more of the shares of the company, and certain shareholders of subsidiaries or persons providing professional services to or holding office in organizations providing services. An independent director cannot be removed without cause unless he or she ceases to be independent, and if he or she resigns, must provide an explanation for such resignation to the shareholders and creditors of the company. Independent directors are given specific rights and functions. This includes the right to engage in agency to provide an independent consulting report on major transactions submitted to the director, and also to propose that meetings of the shareholders or directors to be convened. The importance of ensuring that the independent directors are able to carry out their functions of independent review. 7. When it made clear that a company should review whether an independent director had played a role in overseeing the operations of the company, and also in particular if the performance of his functions had been affected by the actions of the principal shareholder, or if he had been improperly removed from office. So there are a number of stated purposes in requiring a company to have independent directors, including the need for independent directors to represent smaller shareholders, to monitor related party transactions, to act as independent consultant and advisor, and to serve the public interest on the board. So questions have been raised as to the competence and experience of the persons selected as independent directors, as well as their ability to act effectively and independently, and also the willingness of the board and its managers to incorporate and utilize independent directors effectively. So the selection of independent directors appears to be dominated by the majority shareholders through their control of the board of directors and supervisory board. Study suggests that the majority of independent directors have tended to be academics and government officials rather than experienced businessmen and women. So in addition, with some exceptions, the independent directors have not fulfilled the expectation that they would be actively and, if necessary, controversial members of the board of directors. So as a result, some commentators have concluded that the effect of independent directors on the performance of listed companies is minimal. So that would be the end of my reporting. Thank you.
So today I will discuss about the committee in the corporate governance of China. So we all know that committee, it is a group of people who assist the board upon fulfilling its corporate governance responsibilities and operations. So according to the Code of Corporate Governance in the Articles 52 to 58, we have the Corporate Strategy Committee. So Corporate Strategy Committee, it reviews, approves, and synchronizes the strategic plans of business units or divisions. The second one, we have the Audit Committee. So it is a committee who provides oversight of the financial reporting process, the audit process, the company's system of internal controls, and the compliance with laws and regulations. The third one, we have the Nomination Committee. So it is a committee considering a firm's potential board of directors and other key management roles. The fourth one is the Remuneration and Appraisal Committee. So it is a specialized working body under the board which is responsible for formulating and conducting an appraisal standards for the directors and senior management of the company. And last one, the Other Special Committee. So the 2005 opinions of the China Securities Regulatory Commission on improving the quality of listed companies, it defines that listed companies should establish an audit committee and a remuneration and assessment committee. So it is further reiterated in the 2007 China Securities Regulatory Commission of special campaign to strengthen the corporate governance of listed companies. It requires companies subject to the standard to set up an audit committee as part of the requirement for companies to establish a sound system of corporate governance. So, to the recent study of Center for Corporate Governance, Chinese Academy of Social Sciences, that on the top 100 listed companies, it shows that major listed companies in China have made a substantial improvements in the establishment of board committees, particularly in audit committee. So it somehow explains that committees in corporate governance take a guide and procedure to maintain the performance of the company in terms of operations and reputations. So this would take a certain organization perform in adherence of effectiveness and reliability with transparency and validity. So according to Frank Herbert, good governance never depends upon laws, but upon the personal qualities of those who govern. So the machinery of government is always subordinate to the will of those who administer that machinery. So the most important element of government, therefore, is the method of choosing leaders. That would be all. Thank you.
Okay guys, so what do you think regarding their presentations, good corporate governance in terms of China context? So don't forget, we are still one group left, group 7. They are going to discuss good corporate governance in Philippine context. So that's wrap up for today. Thank you for watching.